Good morning. Thank you for joining us today for this webinar on the proposed changes to AS 4000. My name is Corinne Riley-Takos. I'm Chief Operating Officer at Standards Australia, and I will be your host for today. Before we get started, I'd like to acknowledge the traditional owners of the lands we meet today and recognize their continuing connection to land, waters, and culture. We pay our respects to their elders past and present. For today's agenda, I will give you a short overview on Standards Australia and our standards development process and the scope for this specific revision for AS 4000. Joining me today is John Cooper. John is a partner with Jones Day, and we are very grateful for all the work that John and his team have done in working alongside the technical committee in developing the proposed changes to AS 4000. John will be taking you through the proposed changes, and we will also have a lot of opportunities for questions. Throughout the presentation today, you will see a QR code or Slido where you can enter all your questions. We'll try to answer as many of those as possible. As we move along, I just want to give you a background on Standards Australia, particularly for those that are not familiar with the organisation. We are the peak standards body in Australia. We are an independent organisation. We are membership. We are not part of government. And we're in charge of the development of consensus-based standards that support many sectors of our economy. Our standards development process is underpinned by a very robust process that seeks to ensure a broad representation of all the relevant stakeholder groups that will be impacted by the standards we developed. And it's also, as I mentioned before, consensus-based and open to anyone to provide their feedback and input. And in particular, through our public consultation period, which is exactly where we are in this stage of the development of this standard. In terms of our processes, we have quite a well-defined project proposal where we take it through. And I want to just tell you where exactly we are in the process for the development of general conditions of contract. We kicked it off back in June 2022. There's been enormous amount of work done by John, his team, but also the technical committee that's responsible for this work. And I'll talk a little bit about that. And we had a period of drafting, and now we're at our public consultation. We thought it would be really important to give you all an opportunity to understand what the changes are being proposed by the technical committee and give you an opportunity to also comment and provide your feedback and input through that. Once we finalize the public comment, the technical committee will come together again, and they will have to work through all of the feedback received. You will receive feedback on any comments that are provided, and we go into a committee ballot, which is a voting process that ascertain consensus for the publication of the standard. I just want to highlight that as part of our process, when we come together to start the revision of any standard or the development of any new standard, there is an agreed scope of work. I understand that for some of you, you may find that this revision is not going far enough. However, the proposed scope of work is to allow us to move forward and has been underpinned by essentially four key principles. And that is to reflect development in legislation and case law since the 1997 edition. Is to ensure that it will be kept up to date to the contract, tightly focused so as there's no impact in risk allocation between the parties. And also to ensure that the language is much more contemporary. Again, it was a standard that was published quite some time ago. And then also amending terminology and the structure of the contract so it's easier to use and read. If you do have any feedback that sits outside of the scope of the work that has been agreed and is progressed by this committee, we very much welcome your feedback. However, for this specific revision, we will be adhering to what has been agreed as the scope of work. It's not to say that, as an example, risk allocation between the parties it's something that we won't touch. It could be part of the scope of work for a future revision. Finally, before I hand over to John to take you through the detail of the proposed changes, I really want to acknowledge MB10, General Conditions of Contract. That's our technical committee that has been responsible for the drafting and steering the content and the changes that you will see. As I mentioned before, it's quite a broad representative technical committee, and they've been working really, really hard to get to this stage where there is a draft for your consultation. I'll stop talking here. And John, welcome. Thank you for joining us, and I'll hand over to you.
And hello, everyone. First of all, I'd like to pass my thanks on to the committee for the wonderful work they did and the very clear instructions they gave us. And it's certainly my pleasure to join with you all this morning just to run through some of the changes in the new draft from the current AS 4000. In terms of agenda, I have split the presentation into two sections. The first section I'm going to focus on will deal with the major changes contained in the draft. And then from there, I'll move into a discussion of some of the more minor changes that are still important but don't carry the significance of those which I'll discuss in the first part of the presentation. In terms of the major changes, they include the insertion of a formal instrument of agreement as the basis for forming the contract, along with a provision in that part of the document for the insertion or the definition of the contract sum, a redrafting and restructuring of Clause 1, which deals with definitions and principles of interpretation, clarification of how the adjustment for actual quantities of works is dealt with, deletion of the previous Clause 6, which provided for evidence of the contract, and replacement of it with a clause which deals with GST, alignment of the insolvency provisions in the termination clause with current legislative requirements, significant amendments to the dispute resolution clause to allow users greater flexibility in choosing a resolution forum that best meets their business needs. And then finally, in this part of the presentation, addition of a clause dealing with the Personal Property Security Act. First of all, to the formal instrument of agreement. You might recall that the current AS 4000 did not contain such an instrument of agreement. The draft contains one at the very front of the draft. It contains provisions, importantly, to allow for the defining of the contract sum, which must be selected as either a lump sum with the amount to be inserted into the formal instrument, the sum of the products ascertained by multiplying the measured quantity of each section or item of work actually carried out by the corresponding rate for each section or item of work set out in the documents which are to be listed in the formal instrument, or the aggregate of both of those two. And it must be completed by those. Another important set of changes relate to the redrafting and restructuring of Clause 1. All of the definitions have been amended so that they are self-contained. For example, definitions which previously simply referred to the way definitions were referred to or phrases were referred to in clauses such as certificate of practical completion, defects, dispute, latent condition, progress certificate, selected subcontract work, selected subcontractor and test have now all been changed so that the definition contained in clause 1.1 is a complete definition without a need to refer to a clause in the general conditions. A number of definitions have been added or changed to support other changes, including the new GST provisions, the new PPSA provisions, and the significant amendments made to the dispute resolution clause. A definition of document has been added, and this has been closely aligned with the definition of document that is contained in the Evidence Act of 1995. The definition of qualifying cause of delay has been amended to make it clearer. The definition of site has been amended to allow the parties to provide for a specific area which is to be defined in the documents, and that is to sit alongside any other lands and places made available to the contractor by the principal for the purpose of the contract. A definition of work has been added, and that was a phrase that is used throughout the contract, or has been made a separate subclause 1.2 of clause 1, and some new interpretation provisions have been added as follows. References to a person include an individual, firm, or a body, corporate or unincorporate. A reference to legislation or a legislative provision includes any modification or substitution of that legislation or legislative provision, and any subordinate legislation issued under that legislation, and including and includes are not words of limitation. Previous clause 2.5 of AS 4000 dealt with the variations to be made in circumstances where the actual quantities fell outside of the limits of accuracy that were contained within the contract, where there was a bill of quantities or schedule of rates and work was being paid on the basis of measured quantities. This clause has been amended to remove some perceived uncertainty as to when that variation should occur by providing that where, otherwise than by reason of a direction of a variation, the actual quantity of an item of work required to perform the contract is greater or less than the quantity shown in a bill of quantities which forms part of the contract or a schedule of rates, and the principal has accepted a rate for the item of work, the limits of accuracy and the limits of accuracy are stated in item 13, then the rate will apply to the greater quantities if they are within the limits. Otherwise, the rates apply to the quantities up to the upper limit, and the quantities in excess of the upper limit will be a deemed variation, or the rate applies to the lesser quantities if they are within the limits. Otherwise, the entire amount of the lesser quantities are a deemed variation. As I mentioned earlier, clause 6 of AS 4000 provided for the evidence of the contract. And you might recall that AS 4000 did not contain a formal instrument of agreement. As a formal instrument of agreement has been added, there is no longer a need for a clause which deals with that subject matter, and therefore that clause has been replaced with a new GST clause, which provides that the contract sum and all other amounts and consideration in respect of supply under or in connection with the contract are exclusive of GST. If GST is payable by a supplier, as that term is defined in the GST legislation, on any supply made by that party under or in connection with the contract, the recipient of the supply must pay the supplier an amount equal to the GST payable, in addition to any other consideration for the supply. And the clause also provides for the issuing of recipient-created tax invoices. The insolvency provisions, which are contained in the termination clause toward the back of the general conditions in clause 39.11, have been significantly amended to align with changes in legislation relating to bankruptcy and insolvency that have been promulgated since the previous version of AS 4000 was published. One of the most significant changes in this draft is that contained within clause 42, the dispute resolution clause. It has been amended to allow users greater flexibility in choosing a dispute resolution forum that best meets their business needs. Instead of negotiation followed by arbitration, which was the previous process under AS 4000, users can now select one of 4 other options in Annexure Part A in item 36, or continue to use the default mechanism of negotiation followed by arbitration. There's a complete set. The options are negotiation and arbitration, which will be the default if no other option is selected. Negotiation, mediation, and then arbitration. Negotiation, expert determination, and arbitration. Negotiation, mediation, expert determination, and arbitration. And finally, a dispute avoidance board. In addition, the clause provides for the determination by the parties when entered into the contract as to whether the choice of expert determination, if that is the choice in item 39, will be interim binding or otherwise. And if it is chosen to be interim binding, then either party may give notice to the other within 14 days after the receipt by the parties of the expert's determination, stating that it is dissatisfied with the determination. And if such a notice is given in accordance with that paragraph, then the dispute that is the subject of the expert determination is deemed not to have been resolved. In other words, it is no longer final and binding between the parties. A new clause 44 has been added to the general conditions to deal with personal property securities or security interests under the Personal Property Securities Act of 2009. And in particular, it provides that each party consents signing and producing documents, getting documents completed and signed, and provide all information reasonably required by the other party to ensure that each security interest created under the contract is enforceable, perfected, and otherwise effective. Enable the other party to register any interest arising in favour on the PPS register with the highest ranking priority possible, including where applicable as a purchase money security interest, that is one which does not bring into play the first in time rule, and to maintain that registration. And then finally, to enable the other party to exercise its rights in connection with any security interest arising in its favour. In addition, it provides for the recognition of PPSIs in favour of the contractor and the principal by providing an acknowledgement and agreement that one or more security interests arise under the contract over security described in item 15 and the unfixed plant and materials in favour of the contractor. One or more security interests arise under the contract over the security described in item 16 in favour of the principal. And to be clear, those items require completion. In other words, by completing item 15 or item 16, the parties will be making it clear that security interests arise in favour of either the contractor or the principal, respectively. Each security interest described in this clause, that is in items 15 and 16, and in respect of unfixed plant and materials, is registrable under the PPS register. And finally, acknowledgement and agreement that the contract constitutes a security agreement for the purposes of the Personal Property Security Act. I may now briefly turn minor changes, and by minor I'm trying to achieve greater certainty rather than substantive changes such as dealing with GST or PPSA or adding additional forums for dispute resolution. These include mere style changes, some changes to the clause which deals with confidential information, the provisions dealing with the certificate of practical completion, liquidated damages and compensation for delays, and then finally some changes to the annexures. Firstly, the style changes. Throughout the contract, shall has been replaced with must or will. Clause is now used rather than clause or subclause throughout the contract. Antiquated words like thereof have been replaced with appropriate modern English. Use of consistent language for time periods has been adopted by using as soon as practicable rather than a range of terms. The definitions are now in the definitions section in bold in terms of the word or phrase that's defined and capitalised, and throughout the general conditions are now capitalised terms. rather than being italics and a mix of capitalised and non-capitalised terms. Where terms used are defined in legislation, it has been made clear that those definitions in the legislation apply, for example, the GST clause and the PPSA clause. And drafting has been changed to make various conditions easier to read. And examples of these include Clause 21, which deals with the appointment of a superintendent's representative, Clause 34.3, which deals with claims for extension of time, and Clause 37.3, which deals with payment of progress claims. And essentially, in a number of those clauses, additional sentences have been created from the words that were already in existence, as I say, to make it easier to read the various conditions. Clause 8.5, which deals with confidential information, has been amended to provide exceptions to the requirement to keep certain information confidential, and these exceptions include disclosure, which is necessary to enable a party to perform any of its obligations under the contract, whether written consent of the other party is obtained to permit disclosure of confidential information. The disclosure is required by law. The disclosure is to any professional advisor who agrees to comply with this clause as if described by the parties in item 19 of the annexure. I apologise, everyone. Apparently there's been some problems with the internet connection that I'm using, and so we've had to make a swap, and hopefully it'll be a little bit better. Clause 34.6, which deals with the issuing of the certificate of practical completion, has been amended to simply add that the certificate can evidence a date of practical completion which is earlier than the date the certificate is given. The liquidated damages clause, Clause 34.7, has been amended to provide for certification of liquidated damages that become repayable as a result of an extension of time being granted after the liquidated damages have been paid, rather than merely stating that they are to be paid forthwith. So, as I've said, it requires now a certification of those LDs rather than simply the creation of a debt. Clause 34.9 has been amended to provide for certification of compensation for every day which is the subject of an EOT, an extension of time for a compensable cause, and for which a claim for compensation has been made in accordance with Clause 41.1. And the clause then goes on to provide that the compensation is to be calculated as the cost incurred by the contractor that would not have been incurred but for the days the subject of the relevant extension of time, and any damages suffered by the contractor as a consequence of the delays the subject of the relevant extension of time, but only to the extent the compensable cause was a breach of contract by the principal. Finally, the annexures in the draft have been significantly changed. The format has been changed to allow for the easy entering of text and selection of options. An item has been added, as I said earlier, for the defining of the site. As I mentioned earlier, options for the dispute resolution mechanism or forum have been added. As I also mentioned, an item has been added to provide for the binding nature of the expert's determination should that option be chosen. And finally, a deed of novation has been added to Annexure Part D. Finally, once again, I'd like to pass my thanks on to Standards Australia, to the Technical Committee, and to my staff at Jones Day that have assisted in this process. That's it from me, Karine, except for any questions.
Fantastic. Thank you so much, John, for that comprehensive update. I have asked the team for us to jump straight into questions, as I believe there are some that have been put forward. So the first one, and I can probably take that one, is whether the slides will be available post-webinar to the attendees. I assume you're okay, John, with us making your slides available?
Absolutely.
Fantastic. And we have a recording of the webinar as well that we'll also make available as part of the pack. The next question, will the updated AS 4000 continue to be available as a Word document rather than interactive PDF format like AS 4122? I'll take that one. It is our goal to ensure that the Word editable version of AS 4000 will still be made available. We're currently looking at a different licensing model for the contract, but that's a work in progress, and we're hoping to align that with the publication of the new version of the standard. Next question. So the range of dispute resolution routes is great. Will they be selected in Part A as part of contract preparation?
Yes. The relevant item in Annexure Part A provides for the selecting of one of the options, and if no selection is made, then by default it becomes negotiation followed by arbitration, which was the forum which was chosen in the current AS 4000.
Great, thank you. Next question. So when will the new version of AS 4000 come into effect? We are hoping that we'll have a final publication before the end of the year. However, consensus sometimes may take some time, depending on whether the technical committee faces contentious issues. So we don't have a dead set date because the committee needs to agree on the final content, but we're aiming towards the end of the year, the latest early in the new year. The current AS 4000 doesn't align with New South Wales security of payments requirements and therefore has to be amended. Is there any way to include these within the standard form?
I'm happy to address that, Corinne, if you want me to.
Sorry, yes, please.
The technical committee considered whether provision should be included into the draft to align it with the various Security of Payment Act regimes around the country. Ultimately, the decision was made not to do that, and therefore it's not addressed in the current draft.
Great, thank you. Does the latest version cover JIPA and comparable legislation in other jurisdictions across Australia?
Not at the moment, other than the requirements to comply with all laws in the general conditions.
Right. And is there a provision for a bank guarantee?
Yes, there is clause 5. I think it is general condition 5, which is the same as the previous, largely the same as the previous provision, or the provision in the current AS 4000 provides for the provision of security, and an item can be completed to provide for the provision of a bank guarantee. Right. Or, as us lawyers would more precisely say, an unconditional undertaking to pay.
Is the standard based on an ISO standard? I'm happy to answer that one, John. It certainly is not. It is a specific native Australian standard. It is, again, a revision of an existing standard from 1997. I think there's another question for you here, John. Has construction been defined?
No, it hasn't, but there are definitions of work under the contract, works and work. I'm going off memory, but I'm pretty confident that that's the case. What has been added also is a definition of a comprehensive definition of defect.
Right. And is there an option for expert determination to be final and binding? If not, why?
The way it is drafted, the parties can provide for that.
Right. One more. Any change in date OFPC versus date for PC? I'm not quite sure I even know what that means, but over to you, John.
In terms of the definitions, the date. So I can just give me a moment just to check. The date of practical completion has had a minor style change, and the date for practical completion has had no changes other than the style changes, which go to how defined terms are now capitalised and not italicised.
Right. Will a clause be added to cover the legislative requirements associated with modern slavery?
There is no clause which provides for those requirements at present, other than the general compliance with law clause. And I should add, in a number of respects, the technical committee thought that the general clause was sufficient to deal with a number of legislative requirements.
How does AS 4000 contemplate engagement of professional services directly or indirectly required in support of the primary scope of construction work?
In that respect, no change has been made since the previous version of AS 4000. So it would be, in my view, caught by the terms which deal with subcontracts and the requirement of the primary contractor to perform the work under the contract.
Right, thank you. Many organisations use the recommended 10% for profit and overheads. Can this figure be reviewed as part of this review, as it's no longer adequate to cover the cost escalation in overheads over the last 20 years?
I'm assuming that is directed to, and maybe we can ask the author of the question, directed to the pricing of variations. If I could just obtain that clarity first.
Yes, I think we'll need to ask for that to be submitted via Slido. And then just a reminder as well, as we take this moment, that please do keep the questions coming through Slido. Just a reminder that nothing is off the table, so please put your questions through Slido. And when we get clarification on that one, John, we can go back to it. There are a few others coming through, so I might just move through those. If variations for permanent work be more than 20% of the contract value, can BG required to be topped up?
There's no provision for that at present.
Okay, so I think that question that we asked for clarification has come up. I hope that it provides a little bit further explanation. So many organizations use the recommended 10% for profit and overhead. Can this figure be reviewed as part of this review, as it's no longer adequate to cover the cost escalation in overhead over the last 20 years? I'm not sure we got the clarification that you were after, John, so apologies for that. We'll move down to another one. So was there a specific reason to not use business days in clause 37.3?
The technical committee spent a lot of time considering the use of business days rather than calendar days in various parts of the draft, and arrived at very clear instructions that because of the security payment legislation around the country, that the better view was to leave it at calendar days because it was easy to understand, and the timing was likely to align with at least a number of the pieces of legislation around the country. That's as much as I can give you on that. Okay,
great, thank you. There is a question specifically in relation to the project proposal, how the scope of the work has been agreed, what is the process that we undertake to do that. I am happy to comment on that one. As we start and initiate any standards development project, whether it's a revision or a brand new standard, there is a requirement for proposal to be submitted and broadly agreed by relevant stakeholders in terms of the scope of the work, but also that standard generates a positive benefit to the Australian community. In the specific case of AS 4000, we initiated discussions with several nominating organizations, industry bodies, as we refer to them as nominating organizations within standards terms, back in 2021. Some of you may be aware that we had previous attempts of revising this standard, but there were challenges in seeking and achieving consensus as to what should be within the scope of the work. There were a lot of discussions, and the scope of the work were agreed by those various industry organizations and stakeholders that are impacted and heavily involved in the standards development process. And we're very positive that in adhering to that scope of work, we'll be able to seek to continue the project to a successful completion. There's one other question here around, will the new standard make the old version obsolete and unusable? In terms of standards processes, so the new version will supersede the old version. Again, standards are voluntary, and it is up to any parties to use a superseded version of a standard. Evidently, the current version will be AS 4000 with its new designation. But again, any parties may wish to use an older version of a standard. One other question here, will these changes to the AS 4000 roll through to the other standards such as AS 2124? Did you want me to take that one? I think maybe I'm better placed to answer that, John. We absolutely have intentions of revising the entire suite of general conditions of contract. Obviously, we want to finalize this first one. Once it's published, we'll be putting together a comprehensive work program to have all of those changes flow through the entire suite of standards. All right. I think this one is for you, John. So what was the reasoning behind making provisional sums deemed variations?
Can I just add one comment to the previous answer I gave?
Yes, sure.
And that is to say that the 7 days and 21 days being calendar days, not business days, was consistent with the previous version of AS 4000, and that was another reason for the technical committee, I think, leaving that at calendar days. In terms of provisional sums, in a number of areas throughout the draft conditions, the view was taken that where matters are to be priced in accordance with the variation clause, then the relevant clause should refer to that pricing mechanism by deeming it a variation.
And then just a follow-up, I think, from this question, is there a provision to add definition of provision sum?
No, there's no item as such. I don't think. Let me just check that, Irene.
And maybe, John, as you check that, I think it's important for everyone in this call, if there are elements and aspects that you, as revising the proposed standard, think that could be improved or the committee may have missed. This is exactly why we go through this period of public consultation. We welcome any comments that you may have on whether clauses could be changed or whether definitions that have not been included should be included. And the technical committee will then go through in detail of all of the public comments received and address them as they come through. The only caveat to that, which was what I mentioned before, is that it must be within the scope of the agreed scope of the work that we are undertaking this revision. John, over to you.
There is no specific item in Annexure Part A, so the parties, if they want provisional sums, will have to detail those in one of the contract documents that's referred to in the formal instrument of agreement.
Great, thank you. So there's one question regarding risk allocations, which I understand that changes to risk allocation is considered out of scope. If my feedback relates to an amendment that will impact the allocation, how will the committee manage my proposal? and I'm happy to answer that, John, just in terms of the process, the standards development process. So if there will be changes that are being pushed forward that will result in changes to risk allocation, it's unlikely that the committee will incorporate those changes at this point in time. As I mentioned before, please do submit those comments. There is an opportunity for the technical committee to discuss them. The way that we operate, and I know that with this particular standard, given the gap in between the previous edition and this one, there may be a sentiment that revisions don't come forth in a regular basis. But as soon as we publish this revision, we could initiate a new one if there is an appetite and a strong feedback that certain things have not been addressed. So it will be outside of scope for the committee for these revisions, but it doesn't mean that the technical committee and stakeholders can actually advocate for those changes to be incorporated at a later revision or an amendment of the standard down the track. All right, plenty of questions still coming through. So has the hierarchy of documents, drawing specs to realize the project been reconsidered?
Not being reconsidered in the drafting.
They're not.
Yeah, I can't recall whether there was discussion of it within the technical committee meetings. What the formal instrument of agreement does is provide for the listing of the various contract documents, and then clause 8.1 provides for the dealing or handling of discrepancies and ambiguities, and there have been some changes made to that clause to make it clear that it's not just inconsistencies or ambiguities or discrepancies in a document, but it's also between documents. And if that occurs, then notice is to be given and a direction is to be given by the principal's representative. I can't add much more to that, Corinne.
Great, thank you. With the recent changes to unfair contract terms, will this be considered in the review of AS 4000?
Hasn't been considered, and therefore it'll be a matter for Standards Australia and the technical committee as to whether they want to take anything further forward on it.
Thank you. Is the deemed approval of EOT claims still included?
Yes, from memory, there was no change to the risk allocation in that regard, but if you just give me time to check to confirm that. It is still deemed to be an extension of time if it's not dealt with by the superintendent. Sorry, I think I referred to principal's representative before. I should have said superintendent. I've just walked out of another meeting where the other term was being used.
Oh, good. Thank you. Has principal contractor WHS role been picked up?
No, it hasn't been added as a specific provision from memory. However, there is the requirement to comply with all laws, as I've referred to a number of times.
Fabulous. Thank you. So in your opinion, is the new dispute resolution process a valid method for resolving disputes under the Victorian security of payment legislation, noting that the current process is probably not?
That question. It's certainly among the matters that were considered by the committee, and we'd need to look at the type of contract, etc., and what options being chosen in order to form a view on that.
Right. There is another question here. So we do engineering, design, and consultation. Does the 10% deposit apply to our fee structure?
I don't understand that question so far as it relates to this draft. I'm sorry.
No, oh good, thank you. Where are we? Okay, there is a question. Has MB10 prepared a summary of AS 4000 and similar general conditions of contract forms, New South Wales General Conditions 21, in regard to risk allocation between the parties in support of aiding industry adoption?
Aware of.
Sorry?
Not that I'm aware of.
Yeah, and I don't, as far as I'm aware, that hasn't been done. One other question, it might be our final one potentially. Will the new AS 4000 suite provide jurisdictionally specific options or schedules to cover different legislation across states in Australia, or will it be a single Australian standard?
There is no and yes, so it does not provide jurisdiction-specific options, and it will be a single Australian standard.
Great. There's one more, John. Is there a scheduled date for review of the proposed revisions and inclusion of new ones? Will it be 27 years until the next review? Touche. Absolutely not. The goal is that as soon as we finalize this revision, we'll put a structured project plan so we can tackle all the other standards to follow suit. Our primary goal at this point in time is to finalize this one and get a great update back in market, and then we'll work through the others, but certainly not 27 years until the next review. There is a question here as to where people can read the draft, the proposed draft. The proposed draft is accessible from our public platform. So if you go into our website, standards.org.au, and you seek for the public comment section, you will be able to find AS 4000, and you're able to comment on the standard. So as I mentioned before, we're right in the middle of the public consultation. We are very keen to get feedback from as many as you like to put forward. The committee will consider each one of the comments put forward. Consultations open until the 29th of May. We do not provide for extensions, so please be mindful of the deadline. And the website is available on your screen. I want to thank John, his team, for all the work that he has been doing alongside our technical committee. I want to thank our committee members that have been working tirelessly, having regular meetings to get this draft ready for consultation. And finally, I also want to acknowledge Matthew Payne. Matthew is Standards Australia Project Manager. He's been shepherding the committee and our stakeholders through this process and doing a fantastic job. Thank you all for joining us today. I really appreciate it. John, thank you for answering all of the questions for us and on behalf of the technical committee. Again, we invite your comments and wish you a wonderful day. Thank you all.